Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Welcome, I'm Peter Afrasiabi. I'm a partner at the law firm of One LLP. We are an intellectual property boutique with offices in Newport Beach and Beverly Hills, California. We specialize in patent, copyright, trademark, trade secret, right of publicity, and entertainment torts and claims. Today's program is Dead Celebrities. We're talking about the right of publicity. What rights do the estates of deceased celebrities have, and how does this play out? Because you're seeing this more and more every day as technology changes, as the true value, brand value that exists with celebrities emerges more and more. We have to confront these issues. So let's get rolling today as we talk about the right of publicity and dead celebrities. Also, so you know, known as delebs in entertainment parlance talk in Hollywood. We have celebs and delebs. We have it all for you today. On the first slide here, you just see a quick little note from Forbes, and this is Forbes data in 2020. It's looking at the money that the estates have made of famous dead celebrities from monetizing their right of publicity. And so we have here Michael Jackson's estate in 2020 made $48 million just from that right. This is not looking at other rights such as the copyright to his music and the like, of course. Kobe Bryant was number 6 on the list, $20 million. Marilyn Monroe was number 13 on the list, $8 million. So you can see this is a big business that has incredible value, and it's got incredible legal issues that are important for you as a general practitioner, you know, advising local small businesses to be aware of so that they, number one, don't trip over someone's right of publicity, even a long dead celebrity who you may think you have the rights to use something from them. You want to make sure that you don't do that. But you also, maybe you're representing children whose parents were famous celebrities and have passed on, and you want to figure out how to monetize their right of publicity and their celebrity value brand today and going forward. It can be done, and there's a lot to learn. So let's get going and look at what are the issues we're addressing today. We're going to look at what is known as the right of publicity. What is it, and what does it protect? We will look at where the right of publicity comes from, the legal regimes that address the issues that emanate from protecting brand value tied to and built around the identity of a person. And these are state and, in aspects, federal laws. We will look at the scope of these rights, both in life for celebrities. We'll look at fair use defenses and other defenses. And so we're going to look at some famous cases, some really fun, fascinating, cool cases involving celebrities such as Bette Midler, Bob Dylan, Vanna White, Nancy Sinatra. We're even going to talk about Val Kilmer and the famous human cannonball. And then we're going to turn to delebs, our dead celebrities, and we're going to look at some case examples and emerging technology issues that are really stretching and pushing the right of publicity law here. And this involves Jimi Hendrix, Marilyn Monroe, Elvis Presley, the actor Peter Cushing, the victims from the tragedy that was discussed and addressed in the book The Perfect Storm and the movie The Perfect Storm. And ultimately what we're saying is, because of emerging technologies, you can watch Michael Jackson in concert live. Yes, you can today and next year. And you know what? Your great-great-great-grandkids may well be watching holographic, bands of the Beatles and the Rolling Stones play live music and have a great time. This is where we are, and all of those things are wrapped up in the right of publicity. So let's get rolling and talk about the right of publicity. And here we have a big picture overview of the right of publicity. It is statutory or common law based in many states, but not all. It's an intellectual property right at root, and it's the right to protect against the unauthorized use of one's name, image, likeness, or voice for commercial gain. And here's the root right. The root intellectual property right that this is getting at is built around this concept. The right of publicity is the right of every person to control the commercial use of his or her identity. Now, in these different legal regimes, rights can last from 10 years to 100 years post-mortem, and there are different state rules. Some allow it retroactively for celebrities who died a long time ago, some don't. California, for example, is retroactive to anyone who died here after 1915. In Illinois, it applies only to people who died after 1999. Indiana, anyone who died before enactment of the law, and the law was enacted in 1994, Indiana protects them. Post-mortem rights. Some states require that the deceased be domiciled in the state at death or have resided there at death, such as Ohio. Some allow the right to apply to those who did not even live or reside there. And there's some, for example, Indiana, Hawaii, Washington. And there's massive legal uncertainty then as to the enforceability of these non-resident rights emanating from those state codes and state regimes. In fact, there's even questions under the Dormant Commerce Clause whether such state laws are valid and enforceable, but don't worry, today's fun program on dead celebrities is not going to require us to go back to the Dormant Commerce Clause, which sounds like something from the bar exam, if you remember con law in the bar. Now, the other issue here is that some states require a person's name or likeness to have commercial value at the time of death in order to survive their death. For example, California and Texas too. So in practicality, what that means is when I die, my estate has no value. There is no right of publicity value because my name, likeness, voice has no commercial value, it turns out. Some states have commercial registration regimes so that in order to proceed as an estate owner of a deceased celebrity, you have to register with the state that right of publicity and that claim and follow that registration protocol in order to even be able to sue. So that's sort of a high-level 30,000-foot overview of where we are going. But let's pause on our next slide here before we descend into and plumb the depths of the right of publicity and really get our arms around what is the right, how does it work. Let's just take a quick pause. On this slide, you see there a picture of some soda, Mellow Mood, Marley Beverage Co. And this is an example of the use of a right of publicity for a commercial product. And this is a licensed use of the estate of Bob Marley, owns obviously the right of publicity of Bob Marley. And there you have Marley Mellow Mood Soda, a relaxation drink, and with the name and the picture of the famous reggae musician Bob Marley. And so what we want to do here is pause and distinguish between what we are addressing when we're talking about the right of publicity and what we're not addressing. And so this major line of demarcation really finds itself in another branch of intellectual property law, copyright law. And we want to distinguish between right of publicity law and copyright law. So let's go back to what we talked about in the beginning, the Michael Jackson estate. Michael Jackson's estate brings in a fortune from his music alone, and that is copyright-related money. That is not right of publicity money. And so our federal copyright laws allow the owners of copyrights and their heirs to maintain control over that for years after the copyright author's death and the copyright owner's death, and that continues to result in monetization and generation of royalties and the like, which all flow to the estate, and that's hundreds of millions of dollars, right? We're not talking about those types of exploitations, for lack of a better word, not in a dark and nefarious way, but those monetization efforts of a deceased celebrity. Those would be copyright. Another example would be Dr. Seuss's books or the illustrator Schultz who created Charlie Brown, his comics. Those are made perhaps today into TV shows or new works based on the Cat in the Hat or TV shows based on Charlie Brown and his gang. Those would be copyright related issues too. And so those monies that flow back to the estate are copyright monies because copyright protects the creator's music, writings, original works, and those rights obviously live past the creator's life too. And if you want to learn more about that, go watch some cool copyright programs we've done that really give you a great overview of copyright law and how they can last for decades after the death of the creator and even can be taken back by heirs and heirs of estates even when those rights were assigned away during the life of the author or creator. Now, deceased celebrities may well have estates that generate a lot of income from these non-right of publicity areas, and those we're taking off the table today. What we're looking at, by contrast, when we're talking about right of publicity is we're looking at issues that revolve around the commercial use of the name, image, likeness, or voice of a person in commercial endeavors or advertising. And so you can think following. If Elizabeth Taylor's name and face is used to sell skincare products today, that would be an example of using her right of publicity that belongs to her estate because she's deceased. Or our Mellow Mood soda there, and if you're in the mood, go ahead and drink it right now, from Bob Marley, because they're using his name and likeness to sell these Mellow Mood water, sparkling water products. Let's now get to a little bit of the history of the right of publicity to understand even where this comes from. Where did it come from at common law? Where was it before the legislatures in these different states started codifying it and enacting it? Well, we can start really with the right of publicity first being conceptualized in a seminal work written by Brandeis and Warren. This was a law review article they wrote in 1890 on the right to privacy. And this is really where the issue first took root in legal discourse about this idea that one has the right to control the commercial exploitation of their image. And so it existed at common law in various states. And in California, for example, it was codified in the 1970s. And it's now been codified and recognized in 35 plus states. Some states, however, have not codified it and don't recognize it. And this, of course, is a distinct right to copyright and trademark. So all of those lead to the Supreme Court, of course, because we always have the Supreme Court in these programs. And the first time the Supreme Court actually addressed a case involving it was in the 1970s. And the Supreme Court fundamentally recognized the existence, the validity of this right as a common law or a statutory right emanating from the states. And this case was Zucchini versus Scripps Howard Broad Co. at 433 U.S. 562 in 1977. And this involved the playing of some footage of the Human Cannonball's performance on TV by the media outlets, and the performer, the Human Cannonball Zucchini, was not happy because that was his entire show, his persona. His whole thing was, boom, being blasted out of cannonball, flying through the air and landing. And those 12, 13 seconds of him doing that, that was his whole show. That was his persona. That was how he made money. That was it. And so he was obviously unhappy when his whole thing, blasting out of a cannonball, out of a cannon as a cannonball, a human cannonball, was shown on TV. So he sued for right of publicity violation. And the defendants asserted first 14th constitutional defenses, asserting that they had the right. It was video footage they shot. They obviously own the copyright to the footage, which they did. But their fundamental argument, we have the right to film this and then broadcast it. And the Supreme Court said no. The Supreme Court said that the First and 14th Amendments of the U.S. Constitution didn't prevent Zucchini, the performer, whose entire live Human Cannonball act was recorded by the reporter and later broadcast on TV without his consent. And that those constitutional defenses didn't prevent him from bringing a claim against the reporter based on Ohio's right of publicity laws. His persona, his act, was that short video sequence, or that short sequence caught on video. So showing it did abridge his rights, arguably under Ohio state law, and the Constitution couldn't act to protect the news provider from showing it. This was a massively important event in the development of right of publicity law, because for the first time the U.S. Supreme Court waded in and said, absolutely, these state-based rights can have protection in state-based legal regimes, and the federal Constitution won't act to stop them, even legitimate newsworthy type First and 14th Amendment defenses, when it was a full taking of his entire persona, his entire act. That was a big event, and since that 1977 decision, of course, right of publicity has exploded on the scene in terms of litigation cases, in terms of the monetization of living celebrities and dead celebrities, and it's become a bigger and bigger and bigger and bigger business. So let's now go a little deeper and look at the scope and term of the right of publicity, and we'll use California as an example here. California is an exemplary state statutory example. And here it's in the California Civil Code, section 3344, and it protects against the unauthorized use of one's name, likeness, voice, signature, and photograph in commercial advertising. Now, a prima facie case is fundamentally shown by showing a few elements. Was there a knowing use of the plaintiff's protected identity? Was the use for advertising purposes? Was there a direct connection between the use and the commercial purpose? For deceased rights of publicity claims, the right lasts for 70 years after the death of the celebrity and is considered a freely transferable, licensable, and descendable property right. But, and this is a big but, it only exists if at the death the deceased person's right of publicity had commercial value at the time of his or her death or because of his or her death. And that's 3344.1H. Let's pivot to New York. We're going to go to the East Coast now on our next slide and look at the right of publicity in New York, because it's a big deal. As of 2021, New York actually has state statutory right of publicity law. And for decades, New York was famed for not having a post-mortem, at least, right of publicity law. But in 2021, New York joined the fray and started protecting deceased celebrities' rights of publicity, post-mortem rights of publicity, in other words. New York provides a cause of action to a, quote, deceased personality, end quote, for the use of that personality's name, voice, signature, photograph, or likeness in any manner for commercial purposes without consent. And these publicity rights exist in two categories of deceased celebrities. Number one, and this is all as defined by New York law, hence it's quoted here, deceased personalities on behalf of whom damages may be sought for the unauthorized use of their likeness for commercial purposes. And number two, deceased performers, more narrowly defined as actors, singers, dancers, and musicians, on behalf of whom damages may be sought for the non-consensual use of a digital replica, so realistic that the public would believe it was a performance by the deceased, i.e., resurrecting the performer to appear as a hologram or the like, but only when the public would be deceived into thinking that the digital replica was authorized by the deceased performer. As you see on the next slide here, what that law shows is that the New York law really is a blueprint for the modern world. And it's really a fantastic petri dish to look at, because New York waded into post-mortem rights now in 2021. And so it enacted a law cognizant of our new ecosystem. I mean, the California law has been on the books for a while and didn't really grapple with and comprehend these staggering new technologies we have, such as hologram technologies and other technologies we'll talk about soon, that really allow monetization of a deceased performer and the ability to literally resurrect, for example, Humphrey Bogart, and quite literally resurrect him and put him in a movie in a way that starts becoming seamless to the human eye. And so they passed this technology-based right of publicity law really cognizant of these new realities that we have to confront. And so it's really a great blueprint for the modern digital era and then the coming technological changes that are, coming faster and faster every day. So under the New York law, Section 50F2B provides a cause of action where a digital replica of a deceased performer is used in a scripted audio-visual work as a fictional character or for the live performance of a musical work. So, in other words, if you want to host a cool little concert in a little playhouse in New York and you are going to create your cool digital hologram of Whitney Houston and have a little live music show by this digital hologram of Whitney Houston, you can't do it under New York law because she's a deceased performer and that digital replica is illegal. And again, a deceased performer is defined also in the statute as any deceased person who, for gain or livelihood, was, during life obviously, was regularly engaged in acting, singing, dancing, or playing a musical instrument. So it's those sort of content verticals for the dramatic performative arts. Deceased celebrities. And a digital replica is also defined. And again, this is sort of a fantastic statute because it is a legislature's attempt to start getting its arms around these new technologies and these new ways to protect this right in this new era. And so digital replica is defined as follows: an original computer-generated electronic performance in which the deceased performer did not actually participate, but is so realistic that a reasonable observer would believe it is a performance by the individual being portrayed and no other individual. I.e., in my example, you went because it looks like it's a Whitney Houston performance. It doesn't look like it's Britney Spears. You kind of know it's Whitney Houston. It's a hologram of her singing her songs. So what is this aimed at? This is ultimately aimed at the unauthorized use of holograms of deceased performers to generate new performances at concerts or plays, or as part of a movie or television show. Maybe you insert Humphrey Bogart into a new television show idea you have if you're creating great ideas and you're a New York filmmaker or TV maker, or in an online venue. So all of those things are now outlawed in New York. Now let's look at some of the standard statutory common law exceptions to these right of publicity claims. And this is all getting us framed and ready to start learning about Vanna White, Bette Midler, Bob Dylan, Jimi Hendrix, Elvis Presley, you name it. It's coming soon. But here are some standard common law exceptions. In California, the statute contains an exception for uses in connection with any news, public affairs, or sports broadcast or account or any political campaign. And there's also an exemption for uses in plays, books, magazines, newspapers, musical compositions, audiovisual works, radio or TV programs, original works of art, political or newsworthy value, or advertisements of these works. So it creates some sort of a fair use standard that allows fundamentally the development of new additional works that can mention, borrow and address those deceased celebrities without running headlong into a claim that you're violating the right of publicity. And New York has a similar one, and this new New York law says it's not a violation of publicity rights if a deceased personality's name, voice, signature photograph, or likeness is used in a play, book, magazine, newspaper, or other literary work, artwork, or audiovisual work, and any uses that are part of a work of political or public interest or a work that has educational or newsworthy value, including comment, criticism, parody, or satire, are also protected. New York also actually goes further because it says any uses that are part of an audio or audiovisual work, radio, TV program are exempted so long as the work is fictional or a non-fictional entertainment. And the statute further carves out any use in connection with any news, public affairs, or sports program. That's like California. And finally, also protected by the statute are uses in advertisements and commercials for those protected editorial uses. These are known as incidental use exceptions. So in other words, if you have a legitimate work that is a legitimate editorial, political news, work, for example, that may be talking about a deceased celebrity, advertising that work that happens to mention the celebrity doesn't become a use of that celebrity in commercial advertising and violate the statute. Now let's look at a couple cases, and this is really where the First Amendment defenses that could exist collide with commercial exploitation by others. And we're going to look at two different cases here and contrast them because they're on either side of the line. We're going to look at Elvis Presley, and then we're going to look at the famous Perfect Storm story. Let's first look at the Elvis Presley case, and this is the case is reported at Estate of Presley versus Arisen, 513 F Sup 1339. It's from the District of New Jersey in 1981, and here are the basic facts. The defendant created what was called the Big L Show, EL Show, and it was a stage production patterned after an actual Elvis Presley stage show, albeit on a lesser scale. And it had an individual who impersonated the late Elvis Presley by performing in the style of him, wearing the same clothing and jewelry, handing out scarves like Presley did, singing the songs of Elvis Presley, same hairstyle, etc., imitating the singing voice, the poses, body movements, everything. And what the court addressed is that even though the Big L Show contained an informational and entertainment element, it really served primarily to commercially exploit the likeness of Elvis Presley without contributing anything of substantial value to society, in comparison to, for example, a biographical film or play of Elvis Presley, or a production tracing the role of Elvis Presley in the development of rock and roll. And so what the court ultimately held is that although the death of Presley diminishes the impact of certain of the court's reasons, especially economic incentive to produce future performances, i.e., there were no future performances to be given by Presley. Nonetheless, by receiving royalties, the heirs of Presley are the beneficiaries of the right of the individual to reap the reward of his endeavors. And so that stage show, the Big L Show, was shut down as being a violation of Elvis Presley's right of publicity. In other words, that kind of First Amendment expressive right, I want to create a show to do this, didn't protect the Big L Show. The right of publicity trumped. Now let's pivot and look at the other side of the line with the story of the Perfect Storm. Now, the Perfect Storm facts may well be well known to you. These are based on true events in the summer of 1991 when there was a staggering storm that took down a boat off the coast of the United States, and Sebastian Junger wrote the seminal famous book called The Perfect Storm about it, and he went out and did interviews, got public information because it was a big public news story at the time, and then he wrote this book in 1997. And the book was a hit. By the way, it's a great book. There's a plug for Sebastian Junger's book. But nonetheless, great book. Warner Brothers then made a film. Great film too, I thought, based on Junger's book. And Warner Brothers fictionalized for drama the characters, and they noted that it was a fictionalized version of the true story, and that certain characters' dialogue were fictionalized. But nonetheless, they fictionalized it, and then they made the film an immensely successful film. Now, the heirs of the fishermen were unhappy because they felt that their parents or spouses who had died in that tragedy were unfairly characterized, perhaps by some of the dialogue or by their motivations, and were unhappy. So they sued under Florida right of publicity law, and they said that this was an unauthorized use of the deceased original owner of the right of publicity. And this went to the Florida Supreme Court, and the Florida Supreme Court held that the use of the deceased's right of publicity in the film based on true events was protected, and it was not a use of their name or likeness for advertising or commercial purposes to directly promote a product or service. And so the First Amendment protected the filmmakers. And that's a significant decision from the Florida Supreme Court. You could imagine other courts coming out differently, conceivably, and concluding that it was an advertising or commercial purpose for the very thing itself, the film. But nonetheless, it was a true event. It was a newsworthy event. And it wasn't fundamentally about those individuals in a commercial manner using them to sell something. It was about the story and the events, and they happened to be participants in it. And similar example to this is our next case we're going to look at, which is a case involving Bob Dylan and Hurricane Carter, the famous boxer. And so here we have the case of Valentine versus CBS, and this is reported at 698 F. 2nd 430. It's in the 11th Circuit, and it's from 1983. And so what this case involves is a song that was written by Bob Dylan, and it was based upon the murder trial of the famous prize fighter Reuben Hurricane Carter. And all these witnesses testified at the trial, and the trial was a big cause célèbre of that day, of course. And Bob Dylan and another co-writer, Jacques Levy, wrote a song. And Dylan's song talked about sort of the trial of Hurricane Carter. And in the song, it talked about one of the witnesses, Valentine, who was a witness in the trial. And the song intimated that Valentine was a participant in some conspiracy to unjustly convict Hurricane Carter. And so Plaintiff Valentine was unhappy. He felt like, I was just a witness. I was never involved in any conspiracy. It's outrageous. You're defaming me. You're damaging me. You are using my name in your song, and that's a violation of my right of publicity. And this was in Florida, so it was under Florida's right of publicity law. And so plaintiff sues under Florida law, and it ended up in federal court. It's reported at 698 F. 2nd 430 because it was there on diversity. So this is not a federal claim. This is still a state claim. And here's what the court held. This is the 11th Circuit. The trial court properly held that as a matter of law, the ballad Hurricane did not commercially exploit Valentine's name. The defendants did not use her name to directly promote a product or service. Let's pause there. It's kind of like what the Florida Supreme Court was saying. They were not using the names or likeness or characters of the deceased victims in the Perfect Storm event to promote some sort of a product or service. They were telling a story about these true events that happened. And here, same thing. Bob Dylan didn't use Valentine to promote some product or service. It was incidental to this creative, expressive work of the song. And so what the 11th Circuit said is that use of a name is not harmful simply because it is included in a publication sold for profit. An interpretation that the right of publicity statute absolutely bars the use of an individual's name without consent for any purpose would raise grave questions as to its constitutionality. This, of course, then, like the Perfect Storm holding from the Florida Supreme Court, is a recognition that a broad right exists for those uses that we saw from California and New York, these sort of editorial, creative work uses, creative expression uses to touch upon the names of people or use people in a way to create these expressive works that are not commercial advertising or product placement promotional works, but are genuine, creative expressive works or political discourse works or comments on, public murder trials or, terrible tragedies at sea. And so it's an example of courts cocooning and protecting those bodies of filmmakers and content creators from the harmful effects of an overexpansive right of publicity interpretation. Let's now talk about registration standards. California and New York both have them, and California requires that the holder of a deceased person's right of publicity has to register that claim with California's Secretary of State, and the rights holder cannot recover damages for any use that occurs before the registration. This is super important. It's at 3344.1 subsection F1, and it's a very important principle for you, as a practitioner. If you're out there, you're a general, maybe perhaps transactional entertainment lawyer, maybe a wills and trusts lawyer, general practitioner. You may have clients whose parents, for example, you're representing an estate, or the kids of an estate, and the parents may now be deceased, and they may be deceased celebrities. And to the extent you want to be able to go after people unlawfully using that deceased right of publicity, the DeLeb's right of publicity, you need to register first. So one of the first things to have on your checklist, if you're a trust and estate lawyer, for example, when you're dealing with this, is to make sure you get the registration done and done properly. New York is similar. It has a mandatory registration requirement for heirs or representatives who are seeking to monetize through litigation and protect the deceased's right of publicity. Now let's shift from the deceased to the alive. And there's a lot of overlap here. There's not different substantive standards for the celeb versus the DeLeb, but we're going to look at some celeb cases to flesh out the contours of how this right of publicity works when we're talking about, voice. What are we talking about? Likeness. What are we talking about? And those rights, the way they play out for celebs, are no different for the celebs when they become DeLebs. So let's take a look first at this case, the Bette Midler case. And this is Midler versus Ford. It's reported at 849 F. 2nd 460, and this is from the Ninth Circuit in 1988. And here are the basic facts. The Ford Motor Company one day decides it wants to create an ad campaign for the Mercury Sable car. And the idea behind the ad campaign was that they wanted to inspire nostalgic sentiments through the use of famous 1970s songs, and they wanted those songs to be sung by the original artists. And so they went along to Bette Midler, and she had a famous song in the 1970s, Do You Want to Dance? And they asked her, will you do the song for us in a commercial? And basically the way the testimony went from Bette Midler's agent was, Ford Motor Company calls up and says, God, we love Bette Midler. We love her song. We would love for her to sing this. Agent says, is this for a commercial? Yes, it is. Not interested. Click. And that's basically the sum total of the conversation. She was not interested in lending her name, voice, likeness to any commercial endeavors. Now, the company was frustrated, and Ford was like, but we really like Bette Midler's voice. We really want that song. We will go out and get the rights to the song from the copyright holder, which they could do because it wasn't necessarily Bette Midler, her label, to use the song for that commercial purpose. But man, we really wanted Bette Midler to sing it. So the dilemma they confronted was, unable to get Bette Midler, they went and found a voice-alike person, someone who could very well do a voice impersonation of Bette Midler and then sing that song and sound like Bette Midler, so that when you were watching a commercial for the Mercury Sable and you heard the song, you really thought it was Bette Midler, and you then thought, oh my gosh, Bette Midler is sponsoring the Ford's Mercury Sable car. I want to go buy a Mercury Sable, right? That's the theory behind her unhappiness and then her claim for, she of course sued Ford, and that led to litigation, and Ford contended that it didn't violate her right of publicity. And so here's what the Ninth Circuit held. And the quote is fantastic because you only have to start reading the court's quoted opinion here and you very clearly understand where the court's going. Why did the defendants ask Midler to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct her to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of Midler's identity. Its value was what the market would have paid for Midler to have sung the commercial in person. Her human voice, the human voice, is one of the most palpable ways identity is manifested. Very important line. Human voice is one of the most palpable ways identity is manifested. And so what the court held there is that because they used a voice-alike that created the impression that Bette Midler was singing the song for Ford, it actually tripped her right of publicity. Now, let's note here, nota bene, Bette Midler didn't argue that the song was associated with her such that any use of the song would violate her right of publicity. In other words, if they had got Axl Rose to sing the song, Bette Midler wasn't suing saying that upon a consumer hearing the song, "Do you want to dance?" they automatically think, Bette Midler, oh my gosh, I've been hurt. She wasn't saying that. And that's an important line because we're about to go to Nancy Sinatra and these boots are made for walking and see what happens if you push the claim through the wrong prism as Nancy Sinatra did. So let's look at what happens when a singer takes the position that a song itself, whoever sings it, is so associated with them that the use of it by someone else trips the right of publicity. And that brings us to the Nancy Sinatra case and the other side of the line. This case, again, involving a car company, or sort of a car product support company, Goodyear Tire and Rubber Co., is Sinatra versus Goodyear Tire and Rubber. It's reported at 435 F. 2nd 711. And again, it's coming out of the Ninth Circuit, of course, in 1970. The Ninth Circuit tends to get a lot of these, for lack of a better word, Hollywood cases of movies, actors, and famous celebrities. And so here are the basic facts in the Sinatra-Goodyear case. Goodyear liked the song, "These Boots Are Made for Walking." Can't blame them, it's a good jingle. But they liked it and they used that song in a commercial. Now, they didn't use a voice alike of Nancy Sinatra or anything like that. They just got the rights to the song and they got another set of people to sing the song and do a different arrangement of it. So it wasn't evocative of Nancy Sinatra. It was just a song that she had sung and was known for singing, obviously. And so Sinatra brought a trademark claim under the Federal Lanham Act, and she claimed that the song and the arrangement, "These Boots Are Made for Walking," had acquired secondary meaning. And what that means is that the song itself functioned as a trademark indicative of her. The same way, for example, you see the Nike swoosh, you as a consumer go swoosh, it represents Nike, it represents a company, a brand. The Adidas stripes, for example, you think Adidas, you think brand. Those are trademarks. They function to create that association between the mark and the brand or company that stands behind them. And what Nancy Sinatra alleged is that the song itself, "These Boots Are Made for Walking," creates the same mental impression. And so anyone, anytime who makes or delivers a version of that song is tripping over my rights because that song has acquired, it's become a trademark, it's developed secondary meaning, and it's associated with me. And so that was the legal theory Nancy Sinatra pressed, and she lost. The court rejected it because the court concluded to give trademark rights to a song itself would actually collide and clash with federal copyright law. Because federal copyright law posits that Goodyear had every right to license from the rights owner the song and to create another arrangement of the song and another sound recording of the song. That's absolutely allowed under federal copyright law. And so we're not going to have an interpretation of the federal trademark laws that through the back door subvert and gut those lawful copyright behaviors of people. And so the bottom line here that we can look at is that if you try to echo the voice by using a voice alike, then it appears that you are using that person's voice and persona, and you'd be in the Bette Midler camp. So if Goodyear had got a singer to replicate Nancy Sinatra's voice so that when you, the consumer, heard it, you thought Nancy Sinatra, then they would have a problem. But they don't have a problem if they use someone else. And so if you have clients who may be budding entrepreneurs out there who want to start maybe a new makeup brand, and you want to have someone sing "Girls Just Want to Have Fun" as the song, you don't need to go get Cyndi Lauper's right of publicity so long as you don't get a voice like actress that causes people to think that Cyndi Lauper is promoting your client's brand, because then you are using her right of publicity for commercial purposes in commerce. So that's an example of voice on both sides of the line in terms of how voice and a person's persona and identity can work and be protected and not protected in litigation. Now let's shift from voice to likeness. And for likeness, we're still going to be in the Ninth Circuit, and this time we're looking at Vanna White. And this is the famous Vanna White robot case. It's reported at White versus Samsung at 971 F. 2nd, 1395. in the Ninth Circuit, 1992. And there you have a picture of what was frustrating Vanna White, because Samsung created a series of commercials of a robot turning letters on a board, just like the Wheel of Fortune television show. And instead of having Vanna White, it had a robot, but the robot was dressed in nice dresses and jewelry and a blonde hair, echoing Vanna White. And so the robot is sort of echoing the likeness of Vanna White. And Vanna White didn't find it funny, didn't appreciate it, and so she sued, claiming that her California state-based right of publicity rights were violated. And the Ninth Circuit held that television and other media create marketable celebrity identity value. Considerable energy and ingenuity are expended by those who have achieved celebrity value to exploit it for profit. The law protects the celebrity's sole right to exploit this value, whether the celebrity has achieved her fame out of rare ability, dumb luck, or a combination thereof. Because White has alleged facts showing that Samsung and Deutsch had appropriated her identity, the district court erred by rejecting on summary judgment White's common law right of publicity claim. And so that's a really important holding that explains really the breadth of likeness for celebrity value. And what the court was making very clear there that really is important is the court is not going to be involved in making deep artistic judgments about whether this celebrity's brand and persona is a function of kind of rare ability, incredible skill, remarkable sort of artistic, active creative abilities, or if it's just, someone turning letters on a board, which may not be perceived as being something that is deep ability, for example. And so they wanted to make clear that it doesn't matter. If a celebrity has developed a known persona for something, regardless of the underlying artistic merits, California right of publicity law is going to protect it. And so the result was that Vanna White prevailed in terms of undoing the summary judgment and had the right to go to trial as to whether that robot infringed upon her right of publicity. In other words, would the jury think that that was sponsored by Vanna White? And the defense, of course, at trial would be kind of, fair use, parodic, that type of thing. They may try those things. Now, this case, by the way, had a dissenter, and then on the request for the Ninth Circuit to take the case en banc, that was denied, but there was another dissenting judge there. So there's definitely a set of judges who feel that case came out wrongly, but that is a good example of likeness in the celebrity sphere. And so at this point, let's turn from our celebs to our delebs. Now this brings us to Jimi Hendrix, the most incredible guitarist of all time, many believe. And so what we have here is the sole heir of deceased rock legend Jimi Hendrix formed two companies, Experience Hendrix LLC and another company. And the idea behind Experience Hendrix was that it owned all the rights related to Jimi Hendrix, and it would then own those rights, his right of publicity, any trademark rights that the estate had, and then this LLC would be a licensing business in order to license products related to Jimi Hendrix to monetize it. So you can think back to the beginning. The Bob Marley example I gave you was a similar one. The estate of Bob Marley has a company, and then they license it for water or whatever else. And so that's what the business of Experience Hendrix was, as the heir to these rights of Jimi Hendrix. Now, the defendant was a company that was heavily involved in the Jimi Hendrix space in terms of selling products and services bearing Hendrix's name and likeness. And so the defendant's business was one where the defendant actually owned actual products or had licenses to use actual photographs or other original pieces of artwork depicting Jimi Hendrix, for example, and visual artwork created. And so he owned those works. And so the defendant began licensing the right to use the images to produce and sell Hendrix-related merchandise. And so what basically the defendant was saying is that, well, I own this original piece of artwork. I may own the copyright to it. I want to license that to be used on other products. And so I am now attaching this piece of art of Jimi Hendrix to bottled water, let's say, is just a hypothetical example. Or apparel and posters and other things. And a website called hendrixlicensing.com. And so you can imagine that, the owner of the right of publicity and the trademarks to the Hendrix name, Experience Hendrix, wasn't happy that its business was licensing Jimi Hendrix's right of publicity and trademarks. And here's someone called HendrixLicensing.com doing the same thing, ostensibly because they own some physical items that had pictures of Jimi Hendrix. And so it's an example of someone who may even own the copyright to something, stretching that copyright too far to attach it to other objects, where you may have the right to the picture, but you don't have the right to then exploit the underlying right of publicity in that picture on other commercial products. And so it's a little bit of a collision also between copyright and right of publicity law. Fascinating issue. And so the issue is then, does this owning of a lawful copy of a Deleb's art or photo give you the right to use that object on other merchandising or products? And this case is up in Washington. Again, we're in the Ninth Circuit. Just can't get away from the Ninth Circuit here today. And what the Ninth Circuit case reported, Experience Hendrix LLC versus HendrixLicensing.com. It's at 762 F3rd 829, Ninth Circuit 2014. What the Ninth Circuit held is that federal trademark law was violated and Washington state right of publicity law was violated too. And the defendant had asserted actually here nominative fair use defenses. And those defenses basically apply where a defendant may use the plaintiff's mark to describe the plaintiff's product. But this was rejected because the defendant was using the plaintiff's mark to describe his own products. So, by way of example, the defendant could have used the Hendrix mark to describe perhaps that he was selling a photograph of Jimi Hendrix. But he couldn't use the Hendrix mark to say that he is selling a water bottle that has his photograph of Jimi Hendrix on it. And so that was an example of trying to bend and twist the fair use rights to describe what you're selling if you have a lawful copy or object of, if I own a lawful picture of Madonna, I have the right to sell it and I have to be able to tell people it's Madonna. And my act of saying Madonna doesn't trip her right of publicity because I'm just selling a picture of her that I happen to own the picture, right? That's legitimate fair use. This went too far because what he was doing, using my hypothetical, is, oh cool, I own a picture of Madonna. I'm going to put it on a bunch of bottled water and call it the Material Girl Bottled Water. Got a problem vis-a-vis Madonna potentially there. Now let's go from Jimi Hendrix on our next slide to the Marilyn Monroe story. And this is going to be a two-part story. Part one is the Marilyn Monroe right of publicity story. And this is the case of Green versus Marilyn Monroe, LLC. It's reported at 692 F3rd 983, Ninth Circuit, 2011. And so this case involves what is a multi-decade battle over Marilyn Monroe's right of publicity. And the existential question ultimately in the case is, did she have one or did she not? And the issue arises because Marilyn Monroe, as you may remember, died in New York. And at the time, New York did not have any right of publicity for deceased celebrities. So what that means is when she died, her estate possessed at that point no right of publicity anymore. Her right of publicity extinguished with her life. Now, she had a residual will, and through that and all these kind of like entities along the way, nonetheless, her residual will, ultimately all the assets in it, ended up in a company called Marilyn Monroe, LLC, that owned all residual interest. And so it then exploited her right of publicity, and it would license sell it, and it would sue infringers of the right of publicity, contending that it owned Marilyn Monroe's right of publicity. And ultimately, after much battle and litigation in this case, the court held that Monroe LLC owned no such right of publicity because New York never had such a right, and so there was nothing to bequeath to her estate to fall into the residual will as a residual interest to drop down into the LLC through the assignments. And so what happened then is really fascinating, and this shows the power of I guess Marilyn Monroe LLC and those concerned about deceased celebrities and being able to protect brands and that industry, is that California immediately amended its laws to apply retroactively to non-domiciled celebrities. And basically then the parties went back to the court and said, okay, hold on. California law means there was a right of publicity that dropped into her will, and it doesn't matter that she wasn't domiciled in California. California gave her that right, and it went through her will in New York when she died. And what the court held is that no, Marilyn Monroe was never domiciled in California. And so therefore, you'd apply choice of law principles anyway, and no right existed under New York law, and so you can't have, at the end of the day, you can't have this creative way to get around the back door of undoing New York law. No one could, because she had no such right at her death. And so here's the quote from the Ninth Circuit. Because no right of publicity existed in New York in 1962, Monroe's right of publicity was extinguished at her death and did not become part of her estate. And I mentioned earlier, there are cases out there that have dealt with states trying to do what California did as an end run around, and that actually can trigger some dormant Commerce Clause problems, but we're not going there today. But here's where we are going. Here's the final line on the next slide from the Ninth Circuit's opinion, and it's really a beautiful line, I think, and it's an incredible use in a judicial opinion in terms of using the words of a celebrity to put a point on a legal case in an interesting, informative, and useful and very poignant way. Unlike personally, sometimes when you see some of these opinions, for example, dealing with the Cat in a Hat, where they try to do a parody of the Cat in a Hat in the judicial opinion, it doesn't work for me, but maybe you love it. But this, I think, is a very, very good example of such a use. And here's a quote from the Ninth Circuit of this kind of poignant and tragic, really, ending to the case. We observe that the lengthy dispute over the exploitation of Marilyn Monroe's persona has ended in exactly the way that Monroe herself predicted more than 50 years ago. And here's the quote from Marilyn Monroe. I knew I belonged to the public and to the world, not because I was talented or even beautiful, but because I had never belonged to anything or anyone else. Very poignant, very touching. Now, however, let's go to part 2 of the story. And here we have Avila versus the estate of Marilyn Monroe, and this is coming out of New York. At least we're out of California, right? And what we had here was a plaintiff selling goods using the Marilyn Monroe name, and the estate of Marilyn Monroe LLC then sued, saying, we own federal trademark rights, and you're passing off your housewares and products as being associated with her persona, and that triggers her trademark rights, because under federal Lanham Act law, you don't have the right to engage in false or misleading facts and create false associations or endorsements. And what the court held is that even if it's true that no right of publicity existed at her death, the Lanham Act existed, the federal Lanham Act, and so whatever those federal trademark rights were to her name or signature or the prevention of false endorsement, those were inherited down through the residual will ultimately into this LLC. And Lanham Act claims, of course, are distinct to right of publicity ones, and they're much harder to show, but they're showable. And so what you have to show is that not just the use of Marilyn is enough, but rather for a federal trademark analysis, you have to really get to the bottom of how strong is that mark, Marilyn, the similarity of the two marks, the proximity of the products, the likelihood that there's, the plaintiff is going to bridge the gap between the products if there's a difference, actual consumer confusion. Do consumers think that this defendant's use of Marilyn somehow is associated with that Marilyn, right? That kind of causal connection, likelihood of confusion showing, which you don't need for right of publicity. You need here. It's more difficult showing. Defendant's intent in adopting the mark, the quality of the product, and the sophistication of the consumer group. So federal Lanham Act claims are much more difficult to prove, but they are a vehicle left for, arguably, at least in this case, the estate of Marilyn Monroe was saying, against the Avila company in that case. And what the court held is yes, while there is no right of publicity, there were federal trademark rights, and on that fact pattern, there was enough to go to trial. And so what that means is, if you were thinking that you were going to go out and start using Marilyn Monroe's right of publicity, which didn't exist, so you were going to have, do something great with it for a new product, think again, because you'll be hearing from the trademark owners and estate. And so on our next slide, it's just a quick comparison of state versus federal law. And you can really see here on this slide that there's a much harder showing and more difficult case that you have to make on the federal side. And on top of that, you have more expansive federal defenses, and the state side is much easier. So as a practical matter, you want to be on the state side if you can, because it's an easier case to pursue and advance and litigate and ultimately result in money and proceeds coming back to the estate. Now, this raises the issue of, do we have a need for a uniform federal right so that we can preempt the field? In our other areas of intellectual property law, even if we don't have full preemption, like in copyright and patent, which there is full preemption of state laws, we have federal Lanham Act laws and federal trade secret laws that exist concurrently with state trade secret and state trademark laws too. But at least the federal government has created a uniform law. And so the question is, do we want one here? And there's some strong reasons to think that it's time at this point to have a uniform federal right of publicity rule. And the reasons are as follows. We have clearly inconsistent state rules on right of publicity in terms of both the scope of the rights, the amount of protection, the elasticity in those defenses, and then ultimately the duration, 10 years, 100 years, at death, no death. This can have a profound impact fundamentally on assessing anyone's lawful use in this internet era. I mean, it's very complicated to figure out with some states with different rules, some states with no rules. You're on the internet with a business where all business is now conducted. How do you even figure out if what you're doing is lawful or right, or if it's okay? And this makes the transaction costs for businesses astronomical. And so we really, at some level, for that reason alone, need a uniform federal standard. The inconsistent state rules also create forum shopping problems and strategic litigation in different states, which of course then leads, all of this rolls up into staggering expense and uncertainty for businesses to do transactions. And this ultimately, if you think about it, starts chilling expressive conduct just because of the uncertainty, and the transaction costs of figuring it out prohibit people even moving forward. I know in my practice I've had clients come and ask if they can do something with a given deceased celebrity's right of publicity, and the answer is it depends, and we'd have to assess 35 different states and consider federal stuff too, and it's a multi-thousand-dollar endeavor to even figure it out, and businesses say, yeah, can't afford it, I'll come up with a different name, right? I mean, those types of problems are significant problems. It may be unfair for small businesses. And then finally, this gets to sort of the modern technologies. It's not just the internet, but we have developing technologies that get at the use of people's rights of publicity in ways that are profound and significant, get mass airing, because the internet is our main medium of communication now as a people, YouTube, Instagram, social media, and all that. And this gets to sort of now technologies that can exploit that and genuinely injure not just celebrities or celebrities, but also those of us who aren't celebrities and celebrities whose right of publicity may be used, maybe we're, put into a porn video or something, and you have that kind of terrible stuff that happens and injures people. And so here we're going to watch right now this deep fake example of Tom Cruise.
That's why. Oh. It's it's a little embarrassing, it reminds me, I was once in Russia, I ran into Gorbachev. He said, Mr. Movie Star, are you nervous? I said, no, Mr. Gorbachev, I'm not nervous, I know. He goes, well, remember how much a polar bear weighs? I said, polar bear? He said, enough to break the ice. It's the last time I've ever seen Macau Gorbachev.
What's up, TikTok? You guys cool if I play some sports? I love it. More for the audio experience. As much as the momentum. Hey, listen up, sports and TikTok fans. If you like what you're seeing, just wait till what's coming next. I'm gonna show you some magic. It's the real thing. I mean, it's all the real thing.
There you saw. That was not Tom Cruise, but man, it looked and sounded like him, and the mannerisms and everything. And this is why we have this need, I think, for a uniform set of federal rules with the ability to go into one court, federal court, and get a nationwide injunction to deal with these types of things that are burgeoning more and more. And there's a bunch of these on the internet. You can go see them. Also now we're going to look at the next slide of holograms and voice technologies. And hologram concerts have obviously been around for a while. I've seen the Michael Jackson one in Vegas myself. It's incredible. And you'll be able to watch the Beatles in 100, 200 years, or you won't, but your great grandkids will. And we've had, you see there, a picture of hologram actors where you take the blended hologram of Peter Cushing, who's dead, and this is from the Star Wars, and merged him with a character actor so the face was put on him to kind of get some mannerisms. But that's a use of his right of publicity, and so the estate of Peter Cushing needed to be paid for that. assuming we ran a right of publicity analysis and figured out where he died and was it even in America and what are the rules in England, that's a different story. And we have voice technologies that are emerging, and this is sort of a big deal for future commercials and sponsorships and endorsements where a deceased celebrity voice could be brought back to life. And so this is something that couldn't be done 10 years ago, but literally now can. And so here you can watch this quick YouTube video of Val Kilmer, who, as you may know, had throat cancer and has lost his voice, but listen to this video.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking. But despite all that, I still feel I'm the exact same person. Still the same creative soul. The soul that dreams ideas and stories constantly. But now I can express myself again. I can bring these dreams to you and show you this part of myself once more. A part that was never truly gone, just hiding away.
So there you have it, hearing the video. That was Val Kilmer. I heard Val Kilmer. I did not hear a computer. It was absolutely incredible to think that software did that. But that also means we have emerging technologies that are triggering right of publicity claims in potentially amazing ways where software will be able to do that. So what are the tips? Register DSEBs or CLEBs names and signatures, etc. Get them registered with the states. Go register federal trademarks too, because you may or may not have protection. You may want additional protection. You may be places without it. And even though the claims are harder, make sure you preserve all the relevant evidence to those Lanham Act factors I talked about. And I guess at one level you could say, be careful where you die if you're a super rich, famous celebrity. Not that you'd be watching this, but if you are and you know them, they should be careful where they die. It'd be terrible to die in a state where their estate will get nothing. So those are our conclusions in terms of today's program. It's a maze of state laws, and I think really what it gets at is a legitimate need for a uniform federal law here. This is really valuable, important stuff, and it's time to add the fifth leg to the 4 IP areas at the federal level, largely because of these massive new technology fronts. And so I think for you as a practitioner, it's important to be thinking about estate issues that may exist for existing clients or maybe even former clients, and realizing that these assets are out there that hadn't been monetized before but now could be monetized, bringing a voice back to life, for example, and the like. That's our program today on Right of Publicity. I hope you found our Dead Celebrity program useful. As always, if you have any questions, please email me.